I didn't think it would happen like this. Not in this courtroom, not on this day, and definitely not like this. It's strange how quiet a courtroom can feel, even when it's packed with people. The kind of silence where every cough, every scribble of a reporter's pen feels louder than it should. I could hear someone tapping their foot in the back row. The judge hadn't even spoken yet, and still, I knew what was coming. I sat there, watching her, the judge, Lila Hartman. Her black robe hung neatly over her frame, and her face didn't move once. Not even a flicker. She looked at me like she already knew everything about me, like she'd already decided who I was before I ever walked through the doors. That wasn't new. I felt that look before. But something about her eyes felt different, less about the law, more about something else. I couldn't quite name it yet, but it didn't sit right. The cameras were rolling. Of course they were. The press had been circling this case for weeks, twisting headlines like they were writing movie trailers. Musk in the hot seat. Tech titan faces reckoning. Whatever sold more clicks. But none of that mattered now. This was the moment they wanted. Everyone was waiting for it. Then she finally spoke. This court has reviewed the evidence, the testimonies, and the submitted filings, she said, her voice clear, cold. And we find the defendant, Elon Musk, in violation of federal regulatory compliance statutes, with resulting penalties assessed at $200 million. Just like that. No pause, no explanation, no gradual build-up. Just a sentence that landed like a sledgehammer in the room. There was a quiet gasp somewhere to my right. I didn't look. I just stared at the judge. Not in shock, not even in anger. Just focused, listening, watching. She continued. This judgment reflects a pattern of deliberate circumvention of statutory protocols under the jurisdiction of this court, particularly related to oversight within the operations of your subsidiary entities. I won't lie, my heart was pounding. Not because of the fine. Money I could handle. What hit me harder was the word deliberate. Deliberate circumvention. That was a statement of character, not just law. It wasn't just about what I'd done. It was about who they thought I was. I looked at my attorney, Marcus. He was trying to stay calm, flipping through the ruling with his pen shaking slightly between his fingers. I could see in his eyes. He hadn't expected this. Not this version of it. We'd prepared for a penalty, sure, but not one this heavy-handed. Not this tone. 2 rows behind me, I spotted a journalist I recognized. He looked like a kid barely out of college, grinning as he typed furiously on his laptop. His headline was already written before the hearing even began. It always is. I folded my hands together. Everyone thinks I'm the guy who gets angry, who storms out, who tweets fire the moment something goes wrong. But not today. Today, I just sat there, and I thought. The judgment was 89 pages long. Of course, she didn't read the whole thing out loud. But something about the way she spoke, it bothered me. Not because she was harsh. Harsh I can handle. It was how confident she was, how sure she was that she'd wrap this thing up tightly. Too tightly. I glanced at the printed copy Marcus handed me. Page 17 caught my eye. Section 14.3. Just a passing sentence, half a paragraph really. Something about statutory oversight escalation procedures. I couldn't explain it right away, but something about the phrasing looked off. Marcus, I whispered, leaning toward him. Have we seen this clause before? He blinked at me. Clause 14.3. Yeah, it feels familiar. He nodded slowly, flipping back and forth between pages, lips moving silently as he scanned through the text. Maybe. It's not standard wording. No, it wasn't. And I knew that, because I've sat through 100 contracts, 1,000 legal statements, and more compliance briefings than I care to count. That clause didn't look like something that belonged in a judgment like this. Judge Hartman was already moving on, talking about restitution timelines, asset accounting, enforcement protocols. My mind wasn't on her anymore. It was on that clause. I wasn't sure what it meant yet. Not entirely. But I knew how things worked in this world. Sometimes the real power isn't in what's loud and obvious. It's in what's buried in the middle of the noise, hidden behind official-sounding phrases no one thinks to question. The court was adjourned within 15 minutes. The reporters rushed out before the judge even stood up. Everyone wanted to be the first to break the story, the first to spin it into something it wasn't. As I stood, Judge Hartman looked at me. Just for a second. Our eyes met. There was something in that glance. Not arrogance, not triumph, but certainty, the kind that says, you won't fight this. You won't challenge it. You'll take it, because you always do. I didn't say anything, just nodded once and walked out. The air outside the courthouse was colder than I expected. Funny how you don't notice the weather when you're inside a room full of microphones and legal paperwork. Marcus caught up with me on the steps. Elon, we'll appeal, obviously, but the language in this judgment, it's airtight. You saw how she laid it out. I didn't answer him right away. I pulled out the printed copy from my briefcase again, flipping to that clause. Clause 14.3. Oversight, escalation procedures, and regulatory exceptions. It wasn't just that it was vague. It was that it seemed like it was meant to be vague. Like it was written to look clean on the surface, but actually carried more power than it should. Give me everything we have on this, I said. I want to know where this came from. Who's used it before? And why? Marcus hesitated. You think there's something deeper? I don't know yet, I said quietly. But it doesn't feel like a ruling. It feels like a trap. He nodded, lips pressed tight. As we walked toward the car, I saw people watching me. Some with anger, some with pity, some with amusement. That's how it goes. When you win, they call you a genius. When you lose, they call you reckless. But what they don't understand is that I've spent my entire life finding problems where others only see answers. I've built rockets from nothing. I've fought battles behind closed doors most people never hear about. And right now, this wasn't over. It didn't feel over. Because something told me Judge Hartman didn't just write a judgment. She left a fingerprint. One she didn't expect anyone to notice. And I was going to find it. What I didn't know then, what I couldn't know yet, was how deep that fingerprint went, or how many people had already been crushed under the weight of that same quiet clause. But I would soon, very soon, and nothing in that courtroom would ever look the same. There's a strange kind of silence that follows a courtroom loss. It's not the kind you hear in the courtroom itself. That's controlled, formal. But the silence afterward, we were back in the car, windows rolled up, driving away from flashing cameras and microphones. That silence feels colder. Heavier. Marcus sat beside me, quiet, still flipping through the judgment pages, even though we'd already gone over them 3 times. His pen clicked open and closed in his hand. I knew that habit. It only happened when something didn't sit right with him. Pull over, I said. He looked up. What? Just pull over. He turned off onto a quiet side street near a bookstore and parked by the curb. I took the judgment copy from him, flipped straight to clause 14.3 again. I'd been thinking about it all night, even before I left the courtroom. Something in the wording didn't just feel off. It felt intentional. I stared at the sentence again. In the event of a perceived compliance deviation, oversight escalation procedures may be invoked under pre-existing enforcement discretion, including but not limited to summary sanction authorization. It sounded like legal noise. But that's the trick with language like this. It's designed to sound normal, while hiding something beneath the surface. Marcus, I said, still reading the page. What's enforcement discretion supposed to mean in this context? It's broad, he answered slowly. Technically, it gives regulators the power to act without standard checks, usually reserved for emergencies, fraud, national security breaches, stuff like that. But this wasn't an emergency, I said. There was no immediate threat, no fraud. Just a dispute about protocol timelines. Exactly, Marcus replied, which is what makes that clause so strange. It doesn't match the rest of the ruling. I closed the file. Has she used this clause before? Marcus paused. I don't know. Want me to dig into her previous rulings? Yeah, I said. All of them. Especially cases where she issued large fines. Something tells me this clause wasn't written just for me. He nodded and opened his laptop in the passenger seat. As he typed, I leaned back and stared at the sky through the windshield. Clouds moved slowly, like they weren't in any hurry. I envied that for a second. No court dates, no politics, just floating. 10 minutes passed. Then Marcus's fingers stopped moving. Found one, he said quietly. I sat up. One what? A case. 3 years ago. Small energy company, Solar Glen Industries. Judge Hartman used clause 14.3 in that ruling too. Almost word for word. My eyes locked on a screen. What happened to them? They tried to appeal. Lost in court. Company went bankrupt within 6 months. CEO disappeared from public view after that. I took the laptop and read the summary. The case details were eerily familiar. Same language. Same fine structure. Even the timing of the enforcement matched ours. This can't be coincidence, I said. No, Marcus replied. But if you're thinking what I think you're thinking, we're going to need more than similarities. I looked at him. Find the CEO. He hesitated. That was 3 years ago. No interviews, no articles, no social media. Nothing. People don't just vanish, I said. Start digging. He nodded and started searching again. By the time we got back to the office, night had fallen. The city looked different after dark, more honest somehow. People walked faster, spoke less, kept their heads down. It felt like the perfect background for what we were stepping into. I sat in my office, still staring at that judgment file. My team had already heard about the fine, but no one said anything out loud. They kept moving, heads buried in screens, pretending things were normal. I didn't blame them. I used to do the same thing when things went wrong. Just keep building, keep moving. But this wasn't a design flaw we could patch. This was something deeper. Marcus walked in again, holding a printed sheet in his hand. I got a lead. I turned to him. On the CEO, her name was Evelyn Ray. She was a former engineer, built Solar Glen from scratch. After the ruling, she shut everything down. Moved to a town outside Seattle. Real low profile. No new companies, no interviews, no legal filings. But I found an old mailing address tied to a P.O. box she used for business records. It's not much, but it's a start. I stood up immediately. Let's go. You want to go now? Yes. It's a 4-hour drive. Then we better leave now. We hit the road just past midnight. The car was quiet again, headlights cutting through the dark highway. I kept thinking about that clause over and over. The way it was tucked into both rulings. The way it gave power without explanation. After 2 hours, Marcus broke the silence. You really think Hartman's targeting people? I don't know yet, I said. But if she's used that clause before, and it's buried like this, then either no one noticed or no one had the power to challenge it. And you think Evelyn has answers? I think she's the only one who's seen what we've seen and lived through it. We reached the town just as the sun started to rise. It was small, quiet streets, old houses, nothing that stood out. The kind of place you come to when you want to disappear. We parked near the address Marcus had found. A small house with faded paint, ivy growing around the porch rails. I rang the doorbell. No answer. I rang again. After a few seconds, the door cracked open. A woman stood there, late 40s maybe, thin, worn eyes, hair pulled back carelessly. She looked at us like we were the last people she wanted to see. Evelyn Ray. I asked gently. She hesitated. Who's asking? My name is Elon Musk. I know that's probably not something you want to hear today, but I need to ask you something. It's about Judge Lila Hartman. Her eyes changed instantly, flickered with something sharp and cautious. She didn't open the door further. She already took everything from me, she said softly. I don't have anything left to give. I believe you, I said, and I think she's trying to do it again. To me, there was a long pause. Then she opened the door wider. We sat in her kitchen. It smelled like old coffee and forgotten mornings. She poured us each a cup without asking. Her hands were steady, but her eyes kept flicking toward the window, like she still expected someone to show up and take something else away. She used that clause on you too, didn't she? I asked. Evelyn nodded. I didn't even see it at first. It looked like just another paragraph in the ruling. By the time I realized what it meant, the appeal was already in motion, and it was too late. What did it do? I asked. It allowed them to freeze my funding channels before I could restructure, she said. Even though the judgment wasn't final. I couldn't pay staff, couldn't service clients. Everyone pulled out. I was buried before I ever had a chance to fight back. I leaned forward. Why didn't you go public with it? I tried, she said. 3 interviews. 2 were pulled before they aired. The third got buried under a flood of legal threats. I got letters from firms I'd never even heard of. People started distancing themselves. Investors disappeared overnight. Everyone assumed I was the problem. I didn't speak for a while. Neither did she. Then Evelyn looked up at me. You're different. People will listen to you. I don't know, I said. They see what they want to see. But if you're here, she said quietly, it means you saw it too. That clause. You saw what it really is. I nodded slowly. A weapon disguised as procedure. She nodded back. And you're not the only one she's used it on. You're just the first big enough to push back. My mind raced. If what she said was true, if that clause had been used more than once, hidden behind legal jargon and silence, then this wasn't just a courtroom loss. It was something else entirely. Something I hadn't even begun to understand yet. But I was about to. I didn't sleep that night. Even after we left Evelyn's house and drove back to the city, my mind wouldn't slow down. Every word she'd said kept playing in my head. That clause wasn't a mistake. It wasn't just a weird legal term buried in some paperwork. It was something bigger, something sharper, like a knife passed around quietly, hidden beneath formal language and stamped seals. But I still didn't know who was holding the handle. Back at the office, I locked myself in the conference room with a whiteboard and started writing. Names, dates, rulings, clauses. It looked like chaos, but I needed to see everything in front of me. I needed patterns, connections. Marcus came in with 2 coffees and dropped a thick file on the table. 3 more cases, he said. Same clause, same judge. I turned to him. Different industries? He nodded. Aerospace supply chain, clean tech startup, and a crypto firm from 2 years ago. Let me guess, I said. All fined. All tried to appeal. All lost. Exactly, he said, sitting down across from me. 2 folded within a year. The third one still running, but just barely. Their CEO gave up on trying to fight it. I stared at the board. That made 5 cases now. 5 rulings with the same wording. Same judge. Same result. But still no public noise. No investigations. No headlines calling it out. It didn't add up. If it had happened once, maybe it was coincidence. Twice, maybe a legal pattern. But 5 times? 5 businesses, all crippled by the same small clause buried deep inside long rulings? No, this wasn't legal structure. This was strategy. But strategy for what? I needed more. Give me a copy of every ruling Hartman's issued in the past 5 years, I said. That's hundreds of files, Marcus said, raising an eyebrow. Good, I said. Let's see if she ever doesn't use that clause. We spent the next 3 days doing nothing but reading rulings. I canceled meetings, canceled press appearances. People noticed. News outlets started speculating. Was I hiding? Was the fine breaking me down? Was Tesla in trouble? I didn't care. They could say whatever they wanted. Let them write their stories. Because what we were finding in those files was worth more than any headline. Marcus highlighted each time the clause appeared. And slowly, we saw a pattern forming. It wasn't just 5 cases. It was over a dozen. Each one involved tech or energy. Each one included massive penalties. And each one used that same wording. Clause 14.3, buried in the middle of long rulings. Never at the start, never at the end. Always tucked in just deep enough to avoid being noticed right away. But what shocked me most wasn't just how often it showed up. It was how carefully it was placed. Every clause appeared right after a section describing regulatory scope, like it was slipped in once people were already overwhelmed by legal language. Hidden in plain sight. And something else caught my eye. A name. On one of the case files, attached to the enforcement proceedings, was a firm I'd never paid attention to before. Levis and Grant Regulatory Counsel. They weren't well known. Not one of the big firms. No press buzz. But they'd been listed as special advisors on at least 4 of Hartman's rulings. Who are these people? I asked. Marcus looked up. Levis and Grant? Not much on them. Private firm. Small staff. Mostly back-end advisory work. But they're always there when the clause shows up. Yeah, Marcus said, eyes narrowing. Looks like they drafted some of the oversight language, too. I stood up from the table. That's our thread. Pull it. Marcus started digging into Levis and Grant. He found a handful of old case briefs, some archive contracts, even a few government compliance reports where the firm had submitted advisory notes. Most of it looked harmless. But then he found something buried in one of the older documents, an internal memo between Levis and Grant and the Department of Regulatory Oversight. It was almost a decade old, but right in the middle of it, in small print, was a proposed clause template. Marcus, I said, pointing to the screen. That's it. That's clause 14.3. Almost word for word. He leaned in. So, it didn't start with Hartman. No, I said. It started here, with them. And that changed everything. Hartman hadn't written the clause. She'd been using it. But the tool didn't belong to her. It belonged to someone else. Someone who designed it years ago and slipped it into rulings without anyone asking why. But why? Marcus asked. Why build something like this and keep it quiet? I stared at the screen. Because quiet tools don't raise alarms. They don't make headlines. They just work silently. We kept digging. More memos. More documents. And finally, we found something that made my stomach drop. A partnership agreement between Levis and Grant and a private think tank, the Oversight Initiative. It looked like a boring research entity. But when we checked the board of directors, we found a familiar name. Lila Hartman. Before she was a judge. Before she ever sat on a bench. She'd helped draft policy recommendations for that think tank, including regulatory escalation procedures, including language that would later become Clause 14.3. She didn't just use the clause, Marcus said, eyes wide. She helped invent it. That was the missing piece. This wasn't just about rulings. It was about influence, about embedding power into systems where no one would think to look. A clause written quietly, passed through small firms, planted in cases until it became routine, until it became law by habit, not law by merit. And now, it had landed in my case. But there was still something missing. Who else knew? Because Hartman hadn't done this alone. Someone had kept that clause alive, used it across industries, silenced companies, and buried people like Evelyn Ray. We needed help. I picked up the phone and called an old contact, Caleb Nguyen, former federal prosecutor, now a private legal analyst. He didn't owe me anything, but he respected truth more than titles. I sent him the files. 3 hours later, he called me back. Elon, he said, I don't know what you just handed me, but this is bigger than a fine. This is systemic. This clause isn't just bad legal practice, it's targeted strategy. Can you prove it? I could try, he said, but if I start pulling this thread, it's going to shake more than one tree. Are you ready for that? I didn't hesitate. I didn't come this far to stop now. He paused. All right, I'll assemble a team, but you need to be careful. People who build things like this don't like attention, and they don't play fair. I've never needed fair, I said. I just need the truth. That night, I walked into the hallway alone. Everyone else had gone home. The office was dark. My footsteps echoed against the tile floor. I stood by the window and looked down at the city lights below. And I knew something for sure now. This wasn't about a fine anymore. It wasn't even about Clause 14.3. It was about who had the power to shape law in silence, and who had the courage to break that silence wide open. And I had just stepped into the middle of it. But I wasn't going to run. Not now. When the first email came in the next morning, I didn't think much of it. Just a simple message. No name. No subject line. No body text. Just one PDF attached. The file name was a date. Nothing else. But it was the same date Judge Hartman ruled against Evelyn Ray. I clicked it open. It was a transcript. An internal meeting between Levis and Grant and an unnamed third party. The speaker labels were blacked out, but the words were clear. We've confirmed the language was accepted without amendment. Oversight escalation procedures will proceed under the default discretion clause. No red flags triggered. Regulatory silence holds. That phrase hit me hard. Regulatory silence holds. It meant they knew. They knew no one would question it. No one would notice the clause. No one would understand what it was doing. It wasn't just hidden in law. It was built to stay invisible. I forwarded it to Marcus right away. He called me within seconds. Where did that come from? No idea, I said. Anonymous email. But it matches everything we've found. We need to trace it. Already tried. It's routed through 5 different servers. Whoever sent this doesn't want to be found. Or they're watching. That part hung in the air longer than I wanted it to. But the message had been sent. Someone out there didn't want this buried anymore. Someone wanted me to see it. That meant there were cracks forming inside their system. Cracks I could use. I pulled Caleb into a call that same morning. He'd been working through the legal files with his team, trying to build a pattern, trying to find leverage we could use in court. This transcript changes everything, he said after reading it. If we can prove this meeting actually happened, we're looking at intent. That's a whole different battlefield. But proving intent without names is like swinging at shadows, I said. Not if we find a second transcript. Then we look for it, I said. We started combing through everything again. Every email, every court brief, every memo that touched that clause. If they'd held one meeting, there were probably more. The trick was finding them before someone erased the trail. By midweek, we got another hit. This time it wasn't a document. It was a phone call. Marcus had tapped into an old server used by a now-defunct contractor who had briefly worked with Levis and Grant on a compliance project. Most of the files were junk, old invoices, blank forms, autosave drafts. But buried in the audio logs was one voice recording, 23 minutes long. It started quiet. Background chatter. Then a voice came through, low, sharp, too clear to ignore. We packaged the clause within the regulatory context, not as a directive, but as a fallback trigger. Once the primary sanction is accepted, the fallback is automatic. That way, if appeals rise, we're insulated. Another voice responded. What about public exposure? Unlikely. The language is dry. Too technical. Most CEOs don't catch it until it's already activated. They laughed. A short, hollow laugh. One I wouldn't forget. Then came the part that chilled me. The Musk ruling should finalize the precedent. After that, we can formalize it into policy language at the federal level. My hands froze on the keyboard. I played it again. And again. Each time, the words hit harder. I wasn't just another target. I was the final test. They wanted to use my case to turn the clause into law. Not just one court's decision, but national policy. Something that would affect everyone. Every business. Every industry. Forever. They were trying to use my name to legalize a hidden power grab. And now, I couldn't walk away even if I wanted to. Caleb called again within the hour. We need to move fast. If they're planning federal integration, we're running out of time. Then what do? We take this public. You think that'll work? It has to. We scheduled a press conference. I stood in front of the cameras with a stack of files in my hand. No scripts. No PR spin. Just the facts. I told the world about Clause 14.3, about how it had been used, about how it was being slipped into rulings like poison behind a glass of water. I showed the transcript. I played the audio. The media didn't know what to do at first. Some outlets called it conspiracy. Others called it brave. But people started asking questions. That was enough. The next day, news anchors were talking about regulatory silence. Headlines started naming Judge Hartman. Questions poured into legal blogs, forums, and even Capitol Hill. Lawmakers started tweeting about oversight reform. For a moment, it felt like we had cracked it open. But then came the blowback. Emails from legal firms threatening defamation suits. Anonymous letters sent to my staff. One of our data analysts found her apartment broken into, nothing stolen, but files rummaged through. A warning. Then Marcus found a bug under his car. Not a metaphor. A real surveillance device. We weren't chasing shadows anymore. The shadows were chasing us back. I met with Evelyn again. She looked thinner than before, more tired. But her eyes were sharper. I saw your press conference, she said. It was good, but it won't be enough. Why not? I asked. Because they'll push harder now. They'll flood the news with noise, bury the story under distractions. That clause, Hartman's people didn't build it alone. They're part of something older. Older, a structure, she said. A way to control from behind the curtain. It's not just one judge or one clause. It's a system. And once you touch it, it touches you back. I didn't respond right away. I just stared at the floor. Then I said, "What would you do if you were me?" She looked at me for a long time. I'd go deeper. Find the names. Find the funding. Follow the money. So we did. Over the next week, Marcus and Caleb traced the funding routes behind Levis and Grant. Turns out, they weren't independent. Their biggest client was a shell fund registered offshore, with ties to an even larger lobbying entity, one that had donated heavily to judicial appointments over the past 10 years. And right there, buried in a report, was a payment. A direct consulting fee paid to Hartman 3 years before she was appointed judge. For work done under the Oversight Initiative. She hadn't just helped draft the clause. She'd been paid to, and then she'd ruled on cases using it. That was conflict of interest. That was judicial ethics violation. That was something we could use. I handed everything to Caleb. This is the trigger, he said. We bring this to the ethics board. And what if they bury it? They won't, he said. Not with this much heat already in the news. We filed the complaint. That night, I walked out of my office building just before midnight. The air was cold. The streets were quiet. But something felt different, like we had stepped into a new part of the fight. A deeper level, a more dangerous one. My phone buzzed. One message. No name. No subject. Just one line. You're closer than you think. Be ready. And suddenly, I wasn't sure whether the strange part wasn't the message. It was how quiet everything felt after it. For 2 days, no more threats came. No more anonymous emails. No surprise interviews. No press traps. No pushback. Just silence. It was the kind of silence that felt fake, like the moment before a storm hits, when even the birds stop making noise. I knew that silence wasn't peace. It was strategy. It meant they were regrouping, not retreating. And that meant something bigger was coming. But I didn't know what yet. On the third morning, Caleb called. His voice was sharp. Elon, the ethics board is stalling. What do you mean stalling? They've acknowledged our submission, but now they're saying it needs a full procedural review before they can open an inquiry. I closed my eyes. How long is that supposed to take? They won't say. Could be weeks. Could be months. No, I said. They're buying time. Someone got to them. That's what I'm afraid of. I hung up and sat in silence for a few seconds, staring at the file I had just printed out. It was the payment trail from the offshore fund to Hartman's pre-appointment consulting contract. It was clean. Too clean. All legal. All documented. But still, no one had ever looked into it before. No one had bothered asking why a future judge was being paid by an entity tied to regulatory enforcement. That's when I knew we had to move the fight to a place where they couldn't hide behind slow process or sealed chambers. We had to take it back to court. But not just any court. If they want to use my case as precedent, I told Marcus, then we use their own system against them. We file a countersuit. Marcus looked stunned. You want to sue the federal bench? No, I said. I want to sue the process that enabled the clause. The advisory channels. The embedded consultants. Everything they buried under fake neutrality. But that's a monster case. That's uncharted territory. That's where we need to be. We worked overnight to build the framework. Caleb called in 2 more attorneys, one from a constitutional background, one from regulatory litigation. Both read the documents and agreed to join. This isn't just about your fine anymore, one of them said. This could explode half the administrative rulebook if we hit the right pressure points. Good, I said. Then let's aim there. By the end of the week, we filed suit. It wasn't just against the fine. It was a systemic challenge, arguing that Clause 14.3 and others like it were being applied outside their constitutional scope, backed by a network of undisclosed private influence that invalidated the independence of the judicial process. The filing alone made headlines again. Bigger ones this time. But then, just like I fear, they struck back. Not in court. Not in public. They hit me somewhere else. It started with a quiet audit. Then 3. Then 7. Within 3 days, every one of my companies had received some kind of federal notice. Environmental inspections. Labor compliance reviews. Data privacy checks. It was coordinated. Not a coincidence. A squeeze from all sides. My teams tried to keep it contained, but I could feel it. Resources were being drained. Focus was splitting. And it wasn't just a distraction anymore. It was damage. Then came the subpoena. It wasn't about the case. It was about me. Personal communications. Private emails. Financial disclosures. Everything from years ago. They were going fishing, hoping to find anything they could spin into a story, a headline, a scandal. Marcus stormed into my office that afternoon. They're trying to drown you before the court date. I know, I said. And if they don't find something, they'll invent it. I know that too. He looked at me for a second, like he wanted to say more. Then he sighed and sat down. You still sure this is the path? I nodded. If they're fighting this hard, it means we're over the target. But it didn't stop there. Late one night, I got a call from Caleb. They're going after your witnesses. What? Evelyn got a call from a former colleague. Someone tried to offer her a settlement. Quiet money. Disappear money. She didn't take it? No. She called me right after, but means they know who's talking. I clench my jaw. Anyone else? One of the junior analysts we've been working with, she's getting pulled into an unrelated court case. Completely random, but it'll keep her off the stand. I didn't answer right away, because I was realizing something. They weren't just scared of what I'd say. They were terrified of what others might confirm. It meant the clause wasn't the only tool. It was just the tip of a much deeper network, built quietly, layer by layer, with soft influence and untraceable deals. It was an ecosystem designed to look boring, so no one ever questioned it. But now it was being dragged into daylight, and that made it dangerous. That weekend, I asked Evelyn to meet me again. This time we met outside the city, a quiet hill overlooking a lake. She brought a folder with her, old notes, personal records, things she hadn't shared before. I didn't know how far it went, she said. Back then, it all felt like noise, just legal procedure. But I see it now, the shape of it. I flipped through the papers. One stood out, a name I hadn't seen before. Denton Wills. Who's this? He was one of the first drafters for the Oversight Initiative. Worked in regulatory language. Quiet guy. Left the think tank a year before Hartman became judge. What happened to him? No one knows, she said. He just disappeared from the legal world. No firm. No cases. Nothing. I stared at the name, because something about it fell off, like I'd seen it somewhere before. I went home that night and pulled up the transcript again, the one from the anonymous email. I searched the metadata on the PDF. Most of it had been wiped, except one tag, DW_archived_V2. Denton Wills. He hadn't disappeared. He'd been watching. I didn't know where he was, or why he sent the file. But I knew one thing now. Someone inside their system had regrets. Someone wanted the truth to come out. And maybe, just maybe, he was still out there. So I started searching for him. No official leads. No contact trail. Just a name, a shadow, and the hope that not everyone who helped build the system. You ever have that feeling where something's just behind you, but you can't turn around fast enough to see it? That's what the next week felt like. Everything was moving fast, too fast, but it was like I was just barely behind it all. Like I was chasing something I couldn't quite catch. The search for Denton Wills started out slow. We didn't even know where to begin. Caleb brought in a private investigator, someone he trusted from past cases. Quiet, smart, discreet. The guy's name was Rourke. Gray hair, weathered face, voice like gravel. Most people who vanish, he told me the first time we met, don't want to be found. But some leave trails without meaning to. I liked him instantly. No fake polish. Just a man who'd seen too much and still kept digging. Rourke started by pulling every record he could. Denton Wills hadn't filed a tax return in 6 years. No employment. No residence on record. Not even a driver's license renewal. It was like he had wiped himself from existence. But then Rourke found something. Got a lead, he said on a call 2 days later. It's weak, but it's there. What is it? Freight company in Missouri. Used to handle document storage for government contracts. Had a shipping manifest in their archives under a private corporate client. Package logs listed DW as sender 3 times in a span of 2 months. All sent to a law firm in Delaware. What year? Same year he vanished. That was it. A crack in the wall. We traced the law firm. Small operation, mostly handled shell core and off-book advisory work. But one of the partners had retired early, suddenly, just a few months after the last package arrived. I flew to Delaware with Marcus. We didn't tell anyone. No press, no trail. We found a law firm's old office building, now vacant. A dusty lockbox outside still held a few leftover mail items, but nothing useful, until Marcus noticed a small print label peeling off the inside of the front glass door. A contact number, almost faded. I called it. A woman answered. Old voice. Tired. I asked about the partner who retired, Jasper Hayes. She paused before answering. Jasper doesn't see people anymore, she said. I just need 5 minutes, I replied. Another pause. Then, he lives in Camden. I'll give you the address. But I didn't tell you anything. We drove straight there. Hayes lived in a small 1-story house behind overgrown hedges. No doorbell, just a metal knocker and a scratched nameplate. When he opened the door, he looked even older than I expected. Eyes clouded but sharp underneath. He didn't say anything, just looked at me, then turned and walked back inside. We followed him in. I told him why we came. Told him about the clause, the transcript, the audio, the court case, everything. His hands trembled a little when I mentioned Denton's name. I remember him, he finally said. Didn't say much. Just sent things. Legal memos. Notes. Drafts. Do you still have any of it? I asked. He shook his head. Burned it all after I quit. Why? Because I knew what it meant, he said. That clause, it wasn't just bad law. It was a template, a legal weapon, and they wanted it everywhere. You think Denton knew what they were doing? I think he built it. The room went quiet. But Hayes said, there's something you should know. Denton sent one last thing. Didn't go through the firm. He mailed it straight to my house. Said it was his insurance. Where is it now? Hayes walked over to a shelf and pulled down an old leather binder. Inside was a thin manila envelope. He handed it to me. I opened it slowly. Inside were pages of handwritten notes, legal equations, case references. But one thing stood out, a diagram. A flowchart mapping out how the clause had been designed to bypass judicial review by embedding itself into a broader regulation chain. At the center was a symbol. Not a company name, not a court label, just a triangle with 3 dots. I looked up at Hayes. What is this? I don't know, he said. But Denton called it the engine. That word stuck with me all the way back to the airport. The engine. Back home, we ran the symbol through every database we could access. Corporate records, legal filings, trademarks. Nothing. No match. Then Marcus got lucky. He found an old consulting report tied to a defense contractor subcontracting for a policy group. One with indirect ties to judicial lobbying efforts. And buried on page 17 of the appendix, we saw it. The triangle, the 3 dots. It was listed as a model designation, N.G, 3N. Not a name, not a company, a system, a framework, something called embedded neutral governance, model 3N. Suddenly, everything made sense. The clause wasn't just a single trick. It was part of a larger system, a standardized legal mechanism that could be reused across policies. A plug-in template for silent control. And if this model existed, there had to be others. Other clauses, other judges, other cases already affected. We were standing on the edge of something massive, something hidden under layers of boring terminology and legal disguise. But now we had the map. We handed it all to Caleb. He studied it for 2 days straight. Barely slept. When he called again, he sounded different. This changes everything. This isn't just a courtroom tactic anymore. This is policy engineering. Pre-baked legal authority. If we prove this, we're not just defending your case. We're exposing an entire covert system. But will the court even hear it? I asked. They'll have to, because we're not just arguing now, we're naming the engine. We added a motion to the case. Included the E.N.G, 3N model. Named it outright. Cited the source report. Linked it to the clause. We sent shockwaves through the legal community. Blogs exploded with theories. Some experts called it the legal story of the decade. Others said we were paranoid. But no one could ignore it anymore. Even the ethics board responded, reversing course, reopening the Hartman inquiry, and requesting testimony. But as expected, Hartman struck back again. She filed a motion to dismiss the case entirely, calling it baseless and speculative. Said it was a reckless attempt to undermine trust in the judiciary. The court scheduled a hearing, and I knew this was it. The moment everything would either break open or collapse. The night before the hearing, I got one last message. Another anonymous email. This time, no attachments. Just one sentence. He'll be watching from the back row. I didn't know if it meant Denton or someone else, but I didn't care anymore. Let them watch. The courtroom was colder than I remembered. Not in temperature, something deeper. It felt like a place meant to make you small. The walls, the silence, the weight of the eyes watching you from every corner. Even the light felt different, like it was filtered just enough to make everything feel distant. But I didn't care about any of that, because today wasn't about comfort. Today was the day I finally got to speak the truth. No filters, no noise, no press twisting my words. I sat at the table with Caleb and Marcus beside me. The papers in front of me weren't just evidence. They were a map of something we were never supposed to find, something that was never supposed to be seen. And across from me, in her high-back seat, was Judge Hartman. Her expression didn't move. Eyes steady, mouth flat, hands perfectly still on the bench. If she felt any of what we were about to lay down, she didn't show it. That was her game. Always the calm mask, even when the fire was rising underneath it. The clerk called the session to order. The judge tapped the gavel once, and the hearing began. Caleb stood first, his voice calm, clear. He didn't go for drama. He didn't raise his tone. He laid out the motion simply. Our legal challenge to the foundation of Clause 14.3, backed by our discovery of a systemic mechanism called E.N.G. 3N. He passed copies of the documents to the bench. Diagrams, transcripts, Hayes' statement, and a report showing the triangle with the 3 dots right there in black and white. The judge didn't flinch, but I noticed the way her hand paused slightly as she turned the page. That was the first crack. Then Hartman spoke. I find his presentation speculative at best, she said, cool as ice. You present a theory about embedded frameworks without proving a direct application within this court's jurisdiction. Caleb didn't hesitate. That's why we're here, Your Honor. Because the clause applied in your prior ruling matches the language architecture of this model exactly. This isn't a theory. It's a pattern, and it's repeating. Hartman leaned forward just slightly. So you're suggesting my ruling was compromised by a model I had no knowledge of? No, I said, standing up. I'm saying it was designed to function that way, so no one would need to know. Everyone in the courtroom turned toward me, even Hartman. I looked her in the eye. This isn't just about what you knew. It's about what was embedded before you even touched the ruling. The structure was already there. Quiet. Hidden. Waiting. There was a pause. A long one. Then Hartman spoke again. And you have proof this so-called model has affected other rulings? I nodded. We do, but we haven't submitted it yet. She raised an eyebrow. Why not? Because if we showed you everything at once, it would look unbelievable. And that's how this was built. To be too complex, too boring, too technical to raise alarm. But one piece at a time, that's how it unravels. She stared at me for a long second, then turned to Caleb. Continue. The rest of the hearing was slow, painfully slow. Legal arguments, objections, procedural back and forth. But behind all of it, I could feel something shifting, not just in the court, but in the people sitting in the rows behind us. There were reporters, analysts, even a few names I recognized from policy circles. And in the back corner, one seat remained empty the whole time. I couldn't stop glancing at it. Whoever sent that message, they were either watching from the shadows or hadn't shown up at all. At the break, Marcus leaned in. You saw it, right? What? When she paused at the report. That wasn't nothing. I nodded. She knows, even if she won't admit it yet. Then we keep pushing. The second half of the hearing was where it started to feel real. Caleb introduced a new piece of evidence, an internal memo recovered from a contracting agency that had worked on E.N.G. 3N pilot protocols. It listed a timeline of policy implementations, and one of the dates matched Hartman's first draft ruling by less than 48 hours. Hartman's expression changed. Barely, but it was enough. You're saying this court was used as a testing ground, she said. No, I said. We're saying it still is. That was the moment the courtroom shifted. The energy in the room changed. You could feel it. People started leaning forward. Whispers spread in the back row. Even the court stenographer looked up for a second. Hartman sat back in her chair, eyes locked on us. And then, for the first time, she asked a question that didn't sound rehearsed. Do you have a witness prepared to testify to this model's development? I paused, because this was it, the gamble. Yes, I said, but he's not on the record yet. She tilted her head. Then he doesn't exist. That's when the door at the back of the courtroom opened. A man walked in, older, tired eyes, short beard, worn coat, thin Wills. He didn't say a word, just walked straight to the front row and sat down. I looked at Caleb. He looked back at me. Hartman noticed. You're saying that's your witness? I nodded. She leaned forward. Bring him forward. The courtroom went completely still. Denon stood slowly, walked toward the stand. Every step echoed. When he sat, his hands trembled slightly, but his voice was clear when he spoke. My name is Denton Wills. I was part of the design team that developed the language architecture for E.N.G 3N. And just like that, everything changed. His testimony was detailed, exact, and devastating. He explained how the model was built, how it was structured to integrate through harmless clauses, how it was sold to courts as a neutral efficiency upgrade, and how that triangle, the 3 dots, was a marker for policy tracking used internally by think tanks and regulatory firms. Then came the bomb. The clause in question, Denton said, pointing at the file, was an early form. We called it Thread 0. It was used as a benchmark test for adaptive language models in judicial application. Thread 0, Hartman repeated. Yes, it was never meant to be seen as separate. It was just a first test. Hartman sat back slowly. The room was silent. And then something happened that I never expected. Hartman looked at Denton for a long time. Then she looked at me. And for the first time, her voice dropped just slightly when she spoke. I'll need time to review this. The gavel came down. Session ended. And I walked out of that courtroom knowing one thing. We hadn't won yet. But we weren't chasing shadows anymore. We were standing in the light. It felt like the entire world had stopped. The courtroom buzzed with quiet conversations as we left. The air was thick with the kind of tension that only comes from uncertainty. I had expected the usual reactions. People whispering about Denton's testimony, some throwing doubt on it, others questioning its legitimacy. But as we stepped out of the building, the news was already exploding across social media. Headlines everywhere. Mysterious whistleblower exposes hidden legal framework. Court case reveals systemic manipulation of judicial rulings. It was chaos, but it was the kind of chaos I knew could either save us or bury us. We stepped into the elevator, silent for a moment. Caleb and Marcus were processing what had just happened. I was still trying to catch up with it myself. Denton, his testimony, the fact that he had actually shown up. It was surreal. I can't believe he did that, Caleb said as the elevator doors slid shut. Me either, I admitted. But we needed him. We needed that last piece. Marcus, as always, was thinking ahead. This isn't over. Not by a long shot. Hartman's going to fight back. She has too much at stake now. I knew he was right. It wasn't like Hartman to give up easily. Not after we'd exposed something that big. But we couldn't just sit and wait for her next move. The ball was in her court now. But we had to keep pushing. The car ride back to the office was mostly quiet. Everyone was wrapped up in their thoughts. I kept staring out the window, watching the world move on, while everything around me had changed. When we got back to the office, Caleb wasted no time. He started making calls, contacting reporters, and speaking to legal experts. The next step was clear. We had to take the fight beyond the courtroom, get the story out there, and force more eyes on the issue. The more people who knew, the harder it would be for them to bury the truth. But things didn't go as planned. That same night, I got a call from an unknown number. I almost didn't answer, but something told me I should. Mr. Musk, a voice said on the other end. It was a woman's voice, smooth but with an edge. We need to talk. I froze. Who is this? It's not important who I am. What's important is that you listen carefully. You've exposed something that's bigger than you think. And now, people who have more power than you can imagine are paying attention. If you want to survive this, you need to make a choice. My heart raced. What do you mean? The woman's voice dropped lower, almost a whisper. There are forces at play that you don't understand. They're not interested in justice or the law. They're interested in control, and they'll stop at nothing to make sure you don't succeed. I swallowed hard, but my voice didn't shake. I'm not backing down. There was a long pause. Then she spoke again, her tone colder now. You don't get to make that choice anymore. You've already crossed the line. Now, they'll decide what happens next. The line went dead. I stood there, staring at the phone, my mind racing. Who was she? What did she mean by they? And what the hell did she mean by control? I didn't tell Caleb or Marcus. Not yet. They were already dealing with enough, and I didn't want to add more fuel to the fire. But I couldn't shake the feeling that things were spiraling out of our control. The next day, the court scheduled another hearing. This time, Hartman didn't waste any time. She had prepared her defense, her response to everything we had exposed. The courtroom was packed. The media was there. lawyers, reporters, even a few familiar faces from the legal circles we've been dealing with. And there, sitting at the front, was Hartman, calm as ever, but I could see it in her eyes. She was fighting for her life now, and if we weren't careful, she would use every trick in the book to shut us down. The judge called the session to order, and we dove straight into the back and forth. Hartman's defense was as smooth as silk. She dismissed Denton's testimony as hearsay, a desperate attempt from a disgruntled former employee to discredit the entire judicial system. She tried to discredit every piece of evidence we had, downplaying its significance, trying to make it seem like a fluke. But we had one card left to play. Caleb stood up, confident and calm. He looked at the judge, then turned to the courtroom. "Your Honor, we have one more witness." A former associate who worked closely with Judge Hartman during the drafting of the ruling in question. The room went still. All eyes turned to Caleb. Hartman's expression shifted, just for a moment. But it was enough. "Objection," she said, her voice cutting through the tension. "This witness is not on record. He cannot testify without prior notice." Caleb didn't flinch. This witness was a part of the development process for the clause in question. We are not introducing him as a surprise. We are simply requesting that the court allow his testimony. If we're talking about transparency, Your Honor, then this is exactly what we need to prove that the clause was not only intentionally deceptive, but also improperly drafted. The judge looked at Hartman, then back at Caleb. She didn't say anything at first, but I could see her wavering. Then, surprisingly, she gave a small nod. "Proceed," she said. And that was when everything changed. The door opened, and in walked a man I didn't expect to see. Denton's old colleague, Arthur Feller, a quiet, unassuming man who had worked alongside Denton on many of the same legal frameworks. He stepped into the witness stand with a calm demeanor, but his eyes were sharp. He knew exactly what he was doing. When Feller started talking, everything that Hartman had tried to bury came to the surface. He confirmed everything Denton had said, the model, the clauses, the hidden framework. He even went as far as to explain how the clause had been strategically inserted into Hartman's ruling, and how she had unknowingly been used as a tool in the broader system. The courtroom was silent as Feller spoke. It was like watching a dam break. Every word he said shattered the illusion of impartiality that Hartman had carefully built. And with every word, the walls around her started to crumble. Hartman didn't even try to interrupt. She didn't object. She just sat there, her face ashen. By the time the hearing ended, the damage was done. There was no way she could recover from it. No matter how much she fought, she couldn't undo what had been exposed. As we left the courtroom, I felt a strange mix of relief and dread. The fight wasn't over. Not by a long shot, but for the first time, I felt like we had a real chance. We had the truth on our side. We had the evidence. And now, we had people who were willing to stand up and fight with us. But even as the doors closed behind us, I couldn't shake that nagging feeling from the phone call. Someone was still watching. And whoever they weren't done with me yet. Thank you for listening to another exciting story from VIP Vault. If you have enjoyed listening to this story, check out our videos here.